From supplementary list, item number 1.
Yes.
Yes, may we please, Your Lordship.
What is this?
This pertaining to the allegation of double murder.
Sorry?
Two
The allegation of double murder.
Double murder.
Mr. Manta, I will not be taking up any contentious matters
As Your Lordship. Yes.
because last 15 days,
I know.
not right. Parties may have reservations. The appeal is ready for hearing. Full stop. Since this bench may not be available over a long period of time, let the matter appear before an appropriate bench 3 weeks hence.
As Your Lordship. Yes. Keep your best.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
May I please, Your Lordships?
Yes,
Lordship, in this case is for condonation of delay of 35 days. In
that's all right. What is the appeal about?
Lordship, appeal is there's a subsidy matter which the industry petitioner industry is supposed to receive. It's a second round of litigation. In the earlier round of litigation, the denial of subsidy was held as not applicable. The subsidy was in regard to transport subsidy, and
Where is the impugned order?
Lordship, that is at Annexure 2, page 31. In the similar matter, Lordship, there is a second round of litigation, which is the impugned order. In the earlier round of litigation, which is at page Annexure 1, page 27, this Honorable High Court has held that a particular notification, which was
Page
the basis
27.
of
Just a second.
page 27, Lordship, Annexure 1.
No, page 27.
Annexure 1.
Yes.
Order dated 3/5/2019.
Yes.
Lordship will find the relevant paragraph from 5 onwards, Lordship. May I read to Lordship, please?
Yes.
Now the question is as to whether the claim of the petitioner is genuine or not. Same position is clarified by respondent number 5 in the affidavit in opposition by annexing pre-audit report in respect of transport subsidy scheme sent by Under Secretary to Government of India to the Chairman cum Managing Director, Northeast Development Finance Corporation Limited. The pre-audit team during its visit from 19/1/2012 to 28/1/2012 of 64th SLC dated 3/5/2011 had at paragraph 67 to 68 dealt with the claim of the petitioner for the aforesaid period. In the remarks column, it was recorded as under. Lordship may come in the remarks column 7 of the table down below. It was remarked that sanctioned by the 58 SLC held on 7/5/2009 but not audited. The present team audited the case on the request of Directorate as no such guideline was provided by DIPP before issuance of 44-point guidelines about cash payment. Hence, the cash payment made to the transporters by the units have been allowed. What had happened here in the Lordship, for the transport subsidies, the expenses of transportation which was paid by the industrial unit was partly in cash and partly in check. But the Union of India had come out with a guideline saying that entire payment has to be through check and there cannot be any cash payment. However, that guideline was introduced in the month of November 2009, and my period of claim is from October 2008 to December 2008 and January 2009 to March 2009. As such, this Honorable High Court has held that the same notification will not be applicable to the industrial unit. Coming to paragraph 6, Lordship.
Just a second. So the two amounts, as per the relevant order, the two amounts were rupees 134, rupees 94 lakh and 1 crore 38. Against that, you've been given, so the total amount of principal amount of claim was about rupees 232. Against 232, you've been given 134.
Right, Lordship.
Your petition is for the balance amount.
For the balance amount.
For the balance amount.
What had happened?
What has been held Mr. Todi, what has been held ultimately by the single bench, if you come to the thing, come to paragraph 12 of the impugned order.
Very well, Lordship. That's
While
exactly
examining the action of the respondent, this court cannot ignore that when claims are made for reimbursement on cash transactions, sufficient material to substantiate the claim necessary which would not be required if payments are made through bank transactions. Notification dated 20th, therefore submitted by a register introduced to discourage cash transactions, source of flow could not. In the opinion of the court, the scenario therein, burden of substantiating the claim made on the basis of cash transaction would squarely lie on the writ petitioner, subject to verification thereof or claim. Respondent, therefore, not being satisfied with the clearance, as well as pre-audit on being permitted, had their re-verification exercise reconsidered and allowed payment to the extent they deemed admissible. Next, this court in these circumstances, therefore, while sitting in the writ jurisdiction, cannot and is not in a position to render any conclusive finding on the claim of the petitioner. The simple reason is that it's a matter of proof. You have to affirmatively establish that the payments that you claim were made through cash transactions were actually made. That's a question of evidence and proof. In the writ jurisdiction, where we take up matters on affidavit evidence, we do not have the facility of of oral evidence. What you have to do is you have to get your man to say yes. You have to get the other side who was the recipient to say yes, I received it in cash and it is reflected in my books of accounts like this. All this is subject to proof. Therefore, the writ court has not disallowed your claim. All that the writ court has done has relegated you to a suit for the balance claim. So you go and file a civil suit.
No, if I submit, my Lordship, there is what is the case about. In the earlier round of litigation, Lordship, the issue was applicability of the notification, which requires that whether cash payment can be allowed or not. So
the previous order of 2019 was very clear. The previous order of 2019 was very clear. That order specifically required this. Petition disposed of with the direction that the respondent shall reconsider in the light of the aforesaid observations for disbursement of the subsidy amounting to 94 and 138 with interest from the date and to pass appropriate order thereon, whatever permissible under the rules within such time. Now, this is what is permissible under the rules. And they have relied on the 2009 notification or guideline or rule or whatever it is, instruction that cash transactions, so to the extent they verified and they found it appropriate, they released the payment. To the balance extent, you have to prove it before an appropriate forum. We really have no reason to interfere.
There is where my case lies, Your Lordship.
Yes.
Submit. So far, verification of cash payments, whether it was properly done or not, that has been scrutinized by the state level committee as well as the pre-audit team. And the report is reflected in the order.
No, sir, that is not acceptable, because if that was the case, then the first order would have itself said release the payment, because that kind of auditing had been done even before the 2019 order was passed by this court. But this court, despite noticing that, asked them to reconsider. Reconsider does not mean pay. If there had been a mandamus, it should pay this amount. Then, of course, what you say is right. But there was no mandamus for payment. It was for reconsideration.
Reconsideration, Lordship, on a particular point of law, which is that whether the notification will be applicable to my creator of claim, to which the Honorable Court had said it will not be applicable. So once it has been held that it will not be applicable, the other question was not there. Lordship may again come to paragraph 3 of the Annexure 1, the first writ order, Lordship. It appears paragraph 3, Lordship.
Yes.
It appears that for ensuring that the object for grant of subsidy is not misused, the checklist for scrutiny of claims under transport subsidy scheme has been formulated as Annexure A and B to the letter dated 2011-2009 issued by the Ministry of Commerce and Industry, Department of Industrial Policy and Promotion, which inter alia provides that all claims arising from transportation of raw materials and finished goods prior to 10/9/2009 will be examined, re-audited as per checklist of 44 points. Point number 35, which is relevant, provides as under bank statement for payment made to transporters during the period, payment only by check. Paragraph 4, precisely the point for consideration is to whether point number 35 for the period of 1/10/2008 to 31/12/2008 and 1/1/2009 to 31/3/2009 will apply vis-a-vis payment to transporters by check. The answer has to be no. The notification has been issued.
Yes, sir. Yes, sir. But despite that, answer has to be no. So therefore, merely because you paid by cash is not a ground to reject it. The period subsequent to the notification, merely because you paid it by cash, it could have been rejected. But that does not mean that whatever you claim to have been paid by cash would have to be allowed. That means that they will verify, and to the extent upon verification they are satisfied, they will do it. Otherwise, the order would have clearly said that pay this amount. Because this is paid by cash, that is not the order. The order is re-verify and reconsider.
Lordship, so
they may be wrong. Your claim, we are not extinguishing your claim, but this is not an order that we will interfere with.
If I submit one more point before Lordship.
Yes, sir.
There is one single bench order earlier passed by this Honorable Court, where court said that notification is not applicable, number one. Second thing, genuinity of the claim has been settled by the pre-audit team, which is observed in the earlier order, Annexure 1, Lordship. Second, subsequent to that, the respondents has released half of the amount. And again, half of the amount, the reason they have stated that they still don't trust and they want to apply the notification of November 2009.
Let us come to their order, so to say, which you'll find quoted at page 9 of the impugned judgment. Whether the claim is denied for the period which are reviewed, consider and repay. Since the subsidy claim is significantly higher than the first half, which has been denied on account of cash payment, DPIT reviewed the denial and agreed to pay as was paid in the first half of 2008. Under the given circumstances, this should be considered fair and reasonable. Don't trust the cash payments based on subsidy of first half made by check plus simple interest amounting to so and so has been released in settlement of subsidy second half to 8 of 9. This rate of interest of 8% was rate decided by the case given so and so. Provide for payment. A payment made in cash are ineligible for reimbursement. It is further stated that on transport scheme there is no provision of payment or interest on delayed payment. But delayed payments, the Supreme Court has said there is provision for payment. Matter of pending claims, Meghalaya feed products is examined according to direction of total amount of 198, which is 134 interest release. Approved.
So the reasoning given by the respondent is again the same which has been held by the Honorable Court, that the notification is not applicable. And when they are releasing a part of the amount,
we'll clarify the position. We'll clarify the position and say that if you are able to affirmatively establish, then the notification will not stand in the way of the payment being made to you. And you affirmatively establish by evidence in the suit, the notification will not stand in your way.
Lordship, notification is already held, in my submission is already held that it is not applicable, Lordship.
That is exactly what we are going to say. But you have to affirmatively establish. There is nothing over here which says that this may have been paid.
Then that may be made by before the department concerned, Lordship, because already pre-audit has established that. We have proved it before the pre-audit team. We have also established before
very well, we agree with you. We'll allow the department to look at it. But if the department rejects it on any ground, then in that
Lordship.
event, you'll have to file a suit. The writ court will no longer be available to you.
Lordship.
Very good. In view of the good ground shown, the delay in preferring the appeal of about how many days?
35 days. Lord. 35 days. Lord.
35
days.
Is condoned. Full stop. The appeal is directed against a judgment and order of July 8, 2023, by which there are two matters.
Two lordship.
By which
Two different periods.
by which it's a common order, huh? By which the appellants, see if there's more than one appellant.
Same appellant, lordship.
No, but one appellant or many appellants?
One appellant.
By which the appellants, what kind of entity is the appellant? Proprietorship person. Proprietorship
Partnership.
person. Partnership. Registered partnership.
Yes, lordship.
Where is the pleading of registration? In the writ petition. Otherwise, partners have to be made parties. Anyway, by which the appellants' writ petitions in respect of claims for two distinct periods on account of transport subsidy were relegated to a suit. Paragraph. As appropriately noticed in the impugned judgment, comma, this is the second round of litigation. Full stop. According to the appellant, comma, it was entitled to the benefit under the Transport Subsidy Scheme 1971, which had been formulated and notified for grant of subsidy on the transport of raw materials and finished goods to and from selected areas with a view to promote the growth of industries. Full stop. There is no dispute that Meghalaya fell within the selected area A, within inverted commas, of the scheme, wherein, comma, of the scheme, comma, wherein the appellant has an industrial unit. Full stop. Paragraph. Subsidies for diverse periods, DIVERS, diverse periods were disbursed to the appellant upon claims being raised. Full stop. However, two lots of subsidy for the periods of October 1, 2008 to December 31, 2008 and January 1, 2009 to March 31, 2009, comma, respectively, for a total principal amount of rupees 2,33, 44, 480 was not disbursed. Full stop. Indeed, comma, by a letter dated September 2, 2014, the claims for such periods were declined on the ground that the expenses incurred were in cash and payments made in cash were not eligible to be considered for the relevant subsidy. Paragraph. The appellant challenged the decision by way of WP number, by way of two petitions for the two different periods. Full stop. The relevant petitions under Article 226 of the Constitution were disposed of by holding that a notification issued on November 20, 2009 by holding that claims for subsidy prior to September 10, 2009, even if made in cash, were liable to be considered, and claims for any period thereafter, if made in cash, would not be eligible to be considered for the subsidy. Full stop. However, despite this court holding, in the relevant order of May 3, 2019, that claims made for the previous period, even if disbursed in cash, would be considered for grant of the subsidy, the relevant petitions were disposed of on the basis of the following operative orders. Set out paragraph 7 from the relevant order. Full stop. The legal effect, the legal effect of this court's order, which was not challenged by the department, which was not challenged by the union, was that whether or not claims for the previous period were on the basis of disbursement made in cash, they had to be verified and, if found satisfactory upon verification, the claims had to be honored for the release of the subsidy. Full stop. However, despite such previous order of this court and the union having accepted the same, by an order of August 2, 2019, a substantial part of the combined claim in excess of rupees 2.33 crore was declined and only a principal amount of rupees 1,928,52,054 was approved for release. Full stop. The reason recorded in the relevant order was that the subsidy claim during the second half of 2008-09 was significantly higher than what had been paid for the first half of the relevant year. Full stop. The further reference in the relevant order reveals that since some of the payments in respect of the first half of 2008 and 2009 had been denied on account of cash payment, the same principle ought to apply for the claims in respect of the subsequent period. Paragraph. Clearly, this was contrary to the express finding rendered in the order of May 3, 2019, in the earlier round of writ petitions, and which became binding on the parties, including the union, upon the union not challenging the same. Full stop. Paragraph. In effect, what the order of May 3, 2019 required was for the union to re-verify the basis of the claim for the two periods, and if upon verification the appellant could establish that such disbursement as claimed had been made, the requisite subsidy should be released. Full stop. It was open to the court to provide for the subsidy as claimed to be released, however, since the court, in exercise of its authority under Article 226 of the Constitution, did not enter into the veracity of the claim, it required the union to reconsider its position in the light of the observations in the relevant order and re-verify the claims for subsidy for the two periods and release the same within a specified time. Full stop. Paragraph. The union completely misread the order, or, at any rate, acted contrary thereto. Full stop. Paragraph. Notwithstanding the fact that the union failed to exercise the task that was required of it by the previous order of May 3, 2019, and the union rejecting substantial parts of the claims on account of payments having been disbursed in cash by the appellant, in the second round of litigation, the writ court was, not in a position to satisfy itself that the entirety of the claims made for the two periods was genuine. Full stop. This is because writ petitions are heard on affidavit evidence and no oral or other documentary evidence could be received. Full stop. This was the basis for the writ court relegating the appellant's claims to the civil forum for the appellant to affirmatively establish that the disbursements as claimed had been made for the appellant to be entitled to receive the requisite subsidy. Full stop. Paragraph. In appeal, there is very little that can be done at this stage, since evidence cannot be received for this court to be satisfied that the entirety of the claims made for the two periods were actually disbursed for the appellant to be entitled to the amounts as claimed by way of subsidy. Full stop. However, such exercise can be conducted by the union. Full stop. In fact, the previous order of this court of May 3, 2019 obliged the union to conduct such exercise, which the union failed to undertake. Full stop. Paragraph. Accordingly, the appeals are disposed of and the orders impugned are modified by directing the respondents to re-verify the rejected parts of the claims for the two periods by calling for documents and other evidence from the appellant. Full stop. A rational and meaningful verification should be conducted by the union, and the exercise completed the entire exercise completed within 8 weeks from date. Full stop. In the event any part of the claims is to be declined, cogent reasons for such rejection should be furnished. Full stop. Needless to say that the interest awarded in terms of the Supreme Court order, as indicated in the union's order of August 2, 2019, will apply if any part of the balance claim is allowed. Full stop. Paragraph. In the event that any part of the balance claim is disallowed, it will be open to the appellant to institute an appropriate action before a civil forum for such part of the claim. Full stop. Paragraph. WA so-and-so and WA so-and-so are disposed of on the above basis. Full stop. The orders impugned stand modified as indicated. Full stop. the miscellaneous applications are disposed of. Paragraph, there will, however, be no orders to cause.
Lordship's permit, there's a small correction that may be necessary. If Lordship's kindly have page 41,
Yeah.
there was a writ appeal which was preferred, I'm told. It's recorded in the impugned order, my lords.
And writ appeal was dismissed.
Dismissed.
Oh, very well. Where I've said that unchallenged, they just indicate an appeal was preferred by the union, which stood dismissed. By order dated,
My lords, in view of the fact that the order had been complied with.
which stood disposed of, since the union represented in the appeal that the order impugned in the appeal had already been complied with. Just that modify that.
From the main list, item number 1.
You go. Give it to me quickly. Half an hour. Yes.
Lordship, this is a matter regarding the probate matter which is pending in Calcutta High Court.
Since the judgment in the Calcutta matter is still awaited, the matter will appear after a further 6 weeks. Yes.
Obliged, Lordship.
The interim arrangement should continue till expressly directed otherwise. Yes. Done. At least one thing done. It would have otherwise taken a long time.
From the main list, item number 1.
May it pleases your lordship.
Supreme Court case still pending.
Still pending, your lordship.
Since the matter before the Supreme Court has not yet been disposed of, let this one or several matters.
Lordship, all your lordship.
Let this petition do individually. Let this petition appear another 4 months hence. Paragraph. In the event of the matter before the Supreme Court being disposed of earlier, the parties will have liberty to mention for immediate inclusion in the list. Give a date.
1 to 6,
I'm
lordship.
appearing only in
Grateful.
for 1-5.
Grateful much.
Okay, just take the appearances, madam.
1 to 6, your lordship.
Yes.
Yes.
You are appearing, Mr.
Ma'am, I am for the petitioner, my lord, the
Very
CMG
good.
University.
Well, record his name, Mr. Amanpreet Singh, for the petitioner.
Yes,
Thank you.
I'm so grateful.
Obliged, your lordship.
Obliged.
Great.
I'm appearing for nobody.